Welcome everyone to our preview of our panels for this year's Changing Currents in Employment Law on October 29th of this fall from 6 to 9 p.m. And for this edition, we are joined by Jim Murphy. Jim is a partner at Ogletree Deakins in the district. Jim, welcome.
Thanks, Scott.
So tell us a little bit about your background, because you, in addition to being in private practice now, you were had a stint in-house at General Dynamics. Give me a sense of kind of, the perspective that brings and kind of helps you now to best represent your clients.
Yeah, well, I think it probably helps, particularly when you're when as an outside lawyer and dealing with litigation and employment counseling, when you need to kind of put things in perspective, right? You kind of understand what is more critical, what is not as critical for the client, the areas where they might be uniquely sensitive, and sort of the internal politics and challenges that your clients have. When you're looking for that perfect theory in a case, maybe that's not always the thing that they need. But those sort of intangible things I think you pick up a little.
You can tell your client, hey, listen, I've been there, right?
There you go. Yeah, right.
So let's talk a little bit about your panel. Your panel is on anti-SLAPP suits,
Yep.
And we've seen a number of states pass these statutes. Tell us a little bit about kind of what they're designed to do, why
Right.
legislatures pass these, and a little bit of how they're used.
Yeah, I mean, it is a bit of an esoteric topic, isn't it? I mean, but it's actually, when you dig into it, and I think those who do attend the session will really find it a little kind of a creative sort of area for thinking through some of these strategies. But anyway, in anti-SLAPP law, right, you got to know what SLAPP is first. So SLAPP is a strategic lawsuit against public participation. And these statutes were created, right now I think there are about 30 states that have them, including the district. And these statutes were created in order to prevent litigation and the burdens of the discovery process from being used to chill basically First Amendment protected activity. So these laws provide these protections for a defendant, but the defendant could be the individual. So it's important, I think, to plaintiffs' lawyers and lawyers representing individual parties, as well as sort of the corporate employer community when their clients are the defendant in the case. And in a nutshell, in the district, Maryland, and Virginia each have an anti-SLAPP law. They are amazingly different. At one end of the spectrum is a very vanilla statute in Virginia, and then at the other end is a pretty rigorous one in the district. Maryland's probably in between. So there's a great variety between these statutes. Typically, the main thrust of them is that they provide a defendant with an earlier opportunity to have the case dismissed early on in the case, before discovery, where the claims at issue implicate the defendant's First Amendment activity or expressive activity. And the First Amendment really is baked into some of these things. The interesting thing is you wouldn't think that these statutes really have a lot to do with day-to-day, garden variety employment litigation. And that's what I thought for some time, until I got a little more educated about it. And quite frankly, these statutes are now implicated in a lot of non-compete restrictive covenant litigation. We've had some new developments to legislation in Texas to deal with that sort of an issue. Also in California, there was a case involving a major media company who terminated one of their writers for plagiarism, and they were sued for discrimination, retaliation, etc. And ultimately, the California Supreme Court ruled that the anti-SLAPP law actually was available to the defendant media company in that case on the termination claim. And you would think, well, what in the world does that have to do with First Amendment activity, right? Expressive activity. Well, the theory there was the defendant's decision to terminate that employee for plagiarism actually was an exercise of their First Amendment rights in that, well, it was in furtherance of their, let's say, in furtherance of their First Amendment rights.
So at the termination decision itself.
Right. Because the selection of who was going to be handling that work, right, writing the content and being a representative of the defendant reflected, their choice around who was going to communicate on their behalf to the public. And so there was that nexus there. And so it's an interesting decision. I recommend it. It's plaintiff's Wilson, if I get the first name, but it's a good case and a timely one.
So let's talk about individuals, because we know that there's a lot of litigation surrounding employees who leave, and they leave, let's say, with a customer list, maybe, or they leave and they solicit business, or maybe they compete, etc. And sometimes companies will sue them under those circumstances. And we're seeing some litigation where individuals are bringing anti-SLAPP suits in response.
Right.
What kind of advice do you give employers about kind of the ironclad nature of their post-employment restrictive covenants, and really looking at that at the time when they're thinking about bringing suit against an individual?
Yeah, well, oftentimes there are two critical points for the employer, right? There's the point at which somebody is drafting this ironclad agreement up front, and it's designed to not allow anything to slip through the cracks, right? So they typically have very broad, lengthy definitions, etc. And then you've got the point at which somebody actually maybe is in violation of it. One of the critical considerations there is, well, just what is the employer's legitimate interest, right, that is really being implicated by that person's leaving and departure? And is there some kind of a concrete, not only a technical violation of the language, but is that really is the person's departure, they're joining this new employer, really something that's going to implicate the employer's legitimate business interests? And to say that I'm going to to think that an employer is going to use the restrictive covenant to keep somebody on the bench because they might be in their industry and they might be competing against them, that's a harder sell for a court. Yeah, that's a harder sell for a court, right? So part of the challenge, I think, for employers' counsel too is to I think adjust client expectations sometimes with those clauses.
So especially in let's say non-compete litigation. I mean, unless that employer has an ironclad agreement and it's really narrowly tailored, right? Potentially they could be opening themselves up to a countersuit. Yeah, the interesting thing, and this has come up in some of the Texas cases in particular that are now being addressed with legislative amendments, is that, well, where is the First Amendment activity in that, right, in joining another employer? Well, freedom of association, right? That's the theory in those cases. So, and actually the Texas legislature is trying to dial it back, trying to narrow their anti-SLAPP statute, saying that was never the intention of the legislature when they initially enacted it. But that's the way it's written, and that's the way it's been playing out in some cases. Jim, thank you. We look forward to the panel on the 29th. And we look forward to seeing each of you at Changing Currents in Employment Law on October 29th, 2019 at 6 p.m. at the DC Bar.